बुद्धाची मूर्ती त्याच्यावर वरची वरची ते ठेवली त्या अंगावर ही बुद्धाची मूर्ती वरती ठेवली पुढे वरती लिहिता येत दिसते का मूर्ती दिसते ना दिसते येत काहीतरी प्रॉब्लेम टेक्निकल प्रॉब्लेम काल माझं लेक्चर झालं 9 वाजता हो का ते न्यू लॉ कॉलेज मुंबई
Professor Jadhav sir, I think you can start it now.
Yes, sir. I am waiting for Rao sir to join. Now, sir has joined. Hello, Rao sir, should we start? Honorable Vilas Athole sir, with your kind permission, should we start?
Yes, surely, sir.
Okay. I request Chaitrali to take over the chair.
Yes, sir.
A very good morning, everyone. I, Chaitrali Dagodkar, on behalf of Marathwada Legal and General Education Society's Manikchand Pahade Law College, welcome you all to Azadi Ka Amrit Mahotsav National Service Scheme celebrating birth anniversary of Dr. Babasaheb Ambedkar. We would be starting today's event by offering floral respects to Dr. Babasaheb Ambedkar. I request Shubham Teswal to play the slide.
संजू घरातून एक गिलास पाणी घेऊन ये रे.
Thank you very much. Today, we are honored to have with us Shri Vilas Athavale. A brief introduction about Sir. Respected Vilas Athavale, Deputy Secretary, Maharashtra Legislature Secretariat. Sir has experience of practicing law in various courts. While working in Marathwada Legal Secretariat, Sir has advised presiding officers of Legislative Assembly and Legislative Council of State of Maharashtra and worked on number of committees such as Public Account Committee, various joint committees on bills, Committee on Panchayat Raj, and list goes on. Sir has delivered several lectures as guest faculty at Yashoda Pune and Banmati Nagpur, and has also delivered lectures in training programs of probationary officers of Government of Maharashtra. He was Vice President of Caste Tribe Mahasangh, a renowned organization of government employees of State of Maharashtra. We are honored to have you with us today, sir. Now, before moving further, I request Professor Abhay Jadhav, sir, to give welcome address and introduce us all with today's event. Abhay, sir.
Thank you. Am I audible?
Yes, sir.
I would like to begin with wishing we all a happy birth anniversary of Bharat Ratna Dr. Babasaheb Ambedkar. We are celebrating the 131st birth anniversary of a great human being, a great personality who was the chief architect of our Indian Constitution, that is Dr. Babasaheb Ambedkar. I would like to begin with paying my homage and tribute to the portrait of Dr. Babasaheb Ambedkar. Let me welcome our today's chief guest, Mr. Honorable Vilas Athavale, who is the Deputy Secretary of Maharashtra Legislature Secretariat. Sir, I, on behalf of our Marathwada Legal and General Education Society, its Manikchand Pahade Law College, students, staff, I welcome you, sir. We are really very fortunate to have you with us. Every year, we celebrate birth anniversary of Dr. Babasaheb Ambedkar.
I'm not getting your voice.
Hello?
I'm not getting your voice.
Voice is not getting.
Yes, sir. You're audible, sir.
I'm audible.
Yes, yes.
Every year we
Yes,
celebrate birth anniversary of Dr. Babasaheb Ambedkar, inviting a very legal luminaries, the persons who had experienced a lot of things. So today we invited such a great personality, Mr. Vilas, Honorable Vilas Athavale, sir. I think we can give a more justice to celebrate the birth anniversary of Dr. Babasaheb Ambedkar by inviting such persons. And today we have with us Honorable Vilas Athavale, who would be interacting and guiding all of us on the legislative process of our legislature under the Constitution. So I know that you all are very eager to listen him. So hence, with this short welcome address and introduction of the event, I would like to stop myself and I request Honorable Vilas Athavale, sir, to guide all of us. Thank you, sir. Over to you, sir.
Last, sir, is my voice audible to you?
Yes, you are audible. I request.
It's not coming.
Respected
Anybody?
Athavale, sir, can you please increase your volume of microphone and speaker? I think there is little problem. Yes.
Sir, is my voice audible to you now? Vilas sir, is my voice audible to you?
I think some technical issue is there.
So I think sir is not able to listen our voice.
Yes, yes, yes. Okay, I'll talk to him on phone.
Okay, okay. Sir.
Verify whether we are visible or not.
Jadhav sir,
Yes, sir.
respected Atul sir is rejoining.
Hello. Moro sir, you are also not audible.
Okay, sir is joining again.
Okay, okay. So I request all the students, please wait due to some technical reasons. Sir is unable to hear us. So now he is joining very soon.
Yes, sir is there now in meeting.
Now I'm getting your voice also.
Mr. Shubham, can you please make Atul sir co-host?
Yes, sir.
Now getting. Thank you.
Honorable Atul sir, now are you
Yes.
audible? Are you
Yes,
getting
yes,
our
yes.
voice?
It is visible also.
Yes, sir. Yes.
Vilas sir, now I request you to address the attendees.
Yeah.
Respected Atul sir is requested to guide the student.
Now just can I start?
You?
Yes,
Yes.
sir.
Can I start my lecture?
Sir, you can start.
Okay, okay. Thank you very much. Honorable Principal Sir, Dr. Rao, Sir, Honorable Vice Principal, Professor Sri Krishna More, Sir, Professor Abhay Jadhav, Sir, Professor Anuja Singh, Madam, Professor Aparna Kotapalle, Madam, dear all dignitaries, advocates, alumni, and all students. Firstly, I have to pay my humble salutation to Dr. Babasaheb Ambedkar, the great son of this soil. And today, Azadi Ka Amrut Mahotsav arranged by MP Law College, I have been called to join this virtual meeting by Professor Sri Krishna More. I am very much thankful to him that he made me last few days ago in alumni meetings of Dr. Ambedkar Law College, and he requested me to have a lecture on a topic, legislative process under the Constitution of India. I immediately opted him, and just he invited me to join this meeting. And thank you very much to Professor Sri Krishna More. This topic is generally relating to the law students, scholars, advocates, judges, and everyone who is the people of India. Because why? The legislative process is essential to make the laws for the people of the Indian dominion. You see, the legislative process relating with the Constitution of India, that is the supreme legislation in the form of the legislation. You see, the Constitution of India, our Constitution is made, is implementing since 1950, 26 January, and since then we are just getting the fruits of this Constitution at last. The legal process means the legislative process. I think that every article of the Constitution of India, starting from the preamble, is the part and parcel of the legislative process. Because the legislative process starts from every article and it relates with the parliament, legislature, and judiciary and executives. These three wings have been separated from each other, and the powers are separated from each other for implementing the wings of the government. You see, the legislative process, practice and procedure. You see, the legislation is made by the parliament and the legislature. Every legislation is made by the parliament and the legislature of the state. So first of all, we will see how the parliament is formed. The president, Lok Sabha and Rajya Sabha, these three is formed the parliament. Let's say that can be said the parliament. And then we can say the governor, the legislative assembly, and the legislative council, if that state is having legislative council. You see, only 5 to 6 states in India are having the legislative council. The legislature forms from these three wings, that is governor, because he plays very important role to lay the annual financial statement in the house, and by means of that statement, the consolidated fund is to be seen on the face of the record of the legislature. So we will start from the President of India, his election, his powers relating to promulgate the ordinances, pardons, and he has to control the armies, navies, and the air forces. You see, he is the head of the executive of the central, so as the governor is head of the executive of the state. You see, the legislature, whatever legislature is made, that the assent of the president is needed for the final implementation to that law. Or the law, whenever it is made, that is, firstly, it has to be discussed in the floor of the house. The concerned ministry has to make the draft. While making the draft, the concerned ministry asks the opinions from the general public, expert opinions, and so on. The members of the particular house, they can send the suggestions while making the draft on the particular subject. The subject we can see in the 7th list of the Constitution of India, the list, the concurrent list, the state list, and the central list. Out of that subject, we cannot make the law. The subject should be mentioned in the said list, otherwise we are not able to make the law. So the legislation start from the list, any subject you see, and on that subject only law can be made. The constitution of the parliament, we can see that is first the Lok Sabha, by way of electing the people in Lok Sabha, under the RP Act, the Election Commission of India has to declare the election program for that. To that effect, the people has to choose their representative for their constituency, and after electing their representatives, they send it to Lok Sabha. And another form of the representative, that is Rajya Sabha, it is by way of nomination and by way of choosing their representative by the legislative assembly, by the members of the legislative assembly. So these are the election process which is separately evaluated by the separate laws. And after these houses are formed, they can make the law. You see, the leader of the presiding officers, that is chairman of the legislative council or the speaker of the legislative assembly for the state, and Lok Sabha's speaker, so as the Rajya Sabha is the deputy vice chairman, that is the deputy vice president of India is the chairman of the Rajya Sabha, and they has got all powers to supervise the parliament, that is Rajya Sabha and Lok Sabha. Here is one thing, that the leader of opposition cannot be, it is not, the provision is not made in the constitution, because it has been regulated by the parliament by making separate direction by the speaker or the chairman to that effect. So as when the members are there chosen, their qualification and disqualification is also mentioned in the parliament. On the eve of the Dr. Babasaheb Ambedkar's Jayanti, we should not forget that how the Constituent Assembly was made. Dr. Babasaheb Ambedkar was chosen the president or the chairman of the drafting committee of the Constitution, and since then he has taken 2 years, 11 months, and 17 days to make the Constitution. And first draft was made on 26 November 1949, and it was partly allowed, and then entire constitution is implemented since 26 January 1951. So since then, while the draft was making, many critics were there, and some were just appreciating the constitutional draft. And when on 5th of November 1948, the first debate was taken in the Constituent Assembly, Mr. Krishnamacharya said that entire constitution was made by Dr. B.R. Ambedkar, because 7 members were nominated in that committee. One was ill, one was sick, one was died, to be far away from the Delhi, and some member was not attending the meetings of the draft committee. So entire works were depend upon the Dr. Ambedkar. How he worked hardly and prepared the draft and put before the Constituent Assembly. Constituent Assembly has discussed over clause by clause every article, and Dr. B.R. Ambedkar was answered of every queries and answer and question put by the Constituent member of the Constituent Assembly before him. So every person was just participated in the debate of the Constituent Assembly, and every article was discussed thoroughly in that Constituent Assembly. You see, after making such type of draft, Dr. Babasaheb Ambedkar was thinking about the provisions made in the Constitution, that though it is good, but people, those are implementing such Constitution, if those are bad, then it should be sent in well. It should be sent in the dustbin, because it is depend upon the person, those are implementing this Constitution. If the people are good, then Constitution will be good for the people. If they are not good, then it is not useful. It is to be sent in dustbin. So Babasaheb Ambedkar was hoping from this, from implementation of this Constitution from the people, those should be, so in nature of implementing the Constitution. He thought that the Article 32 was the soul of this the Constitution, because he has just mentioned some fundamental rights, directive principle of trade policy, and some other provisions relating to making the laws in this aspect. So why directive principle of state policy have been merged in this constitution? Because any policy matter, that may be the legislation on the backward, legislation on the women, legislation on the child, legislation on the farmer, legislation on the cooperation, legislation on the industry, what kind the parliament or the state government has to make the legislation. So while making the legislation for the public importance and for the benefit of the people of the dominion, so the fruits of that legislation should be given to the people, and to that effect, the implementing agency or the administrative agency, if it is not good, then no use of such type of legislation. You see, many of the legislation are having the ways to interpret for their benefit only, but sometimes the people are going to the Supreme Court by way of filing the writ petition for getting the justice, because the implementation of the laws are not implemented properly by the administration. So the Article 32 was the soul of the Constitution of India. Dr. Ambedkar felt it that this article was the most important in the Constitution. You see, why fundamental rights are important? Because the principle of equality is very important in that relation. Because why our India was having rulings of the kings, several kings. They rule over India many years, and there was inequality as large scale in India in every part of the society. You see, many people on the caste basis, on the religion basis, having discrimination, and to remove that discrimination, Dr. Babasaheb Ambedkar has inducted Article 13 in 8, 13, 14, 15, 16, all these fundamental rights, their right relating to religion, right relating against the exploitation of the people, right relating to thought, belief, and right of education. Just now, before in 2005, were indicted in the constitution. You see, right to education. Though our constitution was implemented in 1950, but people from the backward community, or the people from the tribal community, or people those were neglected from the education, now they are getting good education in the schools. Those are run by the private sectors. You see, the reservation is made there in that schools to get the education to the student, so as the welfare of the women and child. Some laws are made and proper legislation is made by under the powers confirmed by the constitution. So as under Article 187, the state legislatures have got power to make their laws, to implement, to protect the proceedings of the House. You see, the powers are conferred to the legislation under under Article 195 and under Article 118 of the Constitution of India. So you see, the Parliament and the state legislature has got power to make the laws for running their houses respectively, and to make the rules to that effect. So Maharashtra Legislative Assembly and Legislative Council, the rules are made so as the rules regarding the Lok Sabha, rules regarding Rajya Sabha also made. You see, the members of the assembly and members of the legislature are got powers for the powers of privileges, because you see, the member should work in fair and free manner while he is discharging the duties for the benefit of the people, for the public important matter raised in the House itself. When he is not free or under the pressure of the any agency or any people or any authority, if they are not free, they cannot empower certain. They cannot impart the certain powers in favor of the people in Parliament or in the legislature house. Why? Because you see, 195 is very clear. So as the proceedings are also protected in courts, court cannot entertain the proceedings of the House, because the whatever it speak by the member in Parliament or the legislation, that has been protected. Because why? The said proceedings are under the protection of the House, and under Article 212, those proceedings are protected. So as whoever the judges under Article 211, they are also protected. Their speech, their dialogues, their judgments, and their whatever they give directions to that effect in the judgments, or while they are speaking in the open court or making remarks, they also have been protected under Article 2:111. So as the governor or the president of India, they are also protected from filing the criminal petitions against them, or to ensure any civil petition file against them in any court of law. They are protected uh, from filing the suits against them. So you see, these legislation are made that they should work freely and fairly in respect of power conferred by this constitution upon them. Unless they are not free, they cannot work properly in favor of the people. Why? Why? Because the minds are different of the people. One can act for their benefit. One can act for the benefit of the society, and one can act for the spoiling the society. So you see, there should be anonymously favoritism in favor of the members. To that regard, they have been protected from getting the privileges. No one can file the petition against the speech delivered in the house by the member of the house, or the member of the parliament, or the member of the legislative assembly. And even if the member, suppose any member is prevented from going to the house to discharge his duty, he can knock the door of the justice. No police officer can also detain him without any sufficient cause, without any indulgence of the criminal activities. So as the committees of the parliament or the committees of the legislature, they are also protected. Their proceedings are also protected, and the speech delivered in the committee or parliament house, these speeches are also protected. Those speeches or those proceedings, no one can challenge in any court of law. So this is another. This is one aspect. Another aspect, to introduce the bill, to file the bill, to file the bill in the house, to introduce the bill in the house. The kinds of the bill are two kinds. Those one is the money bill, that is financial bill, and another is the ordinary bill. Money bill can introduce only the house of the people, that is Lok Sabha, or Rajya Vidhan Sabha, that is the state legislature, that is Vidhan Sabha, or this legislative assembly. It cannot be introduced in the house of Rajya Sabha, that is house of state council of states, or the legislative council, if the house is having two houses in any of the state. So there is one house only, legislative assembly, that can be introduced and passed. If there are two houses, the money bill or the financial bill can only be filed, can only be introduced only in the state assembly, that is the Vidhan Sabha or the Lok Sabha, in relation to parliament, or in case of the parliament. So if the bill has to be introduced in the Lok Sabha, firstly, before introducing it, the speaker has to certify it, that is, this is the money bill. Unless he will not certify it, that bill cannot be introduced in the Lok Sabha. So his certification is very necessary to get it filed. In that bill, it is that the contention is there that the receipts and the expenditure out of the consolidated fund of the India or the consolidated fund of the state, as the case may be. The case may be of parliament, or the case may be of the state legislature. The provisions are the same, because the house of people only are got power under Article 107 of India, that money bill only can be introduced in the Lok Sabha or Rajya Vidhan Sabha. So if money bill, after passing of the money bill, it goes to the Rajya Sabha, and Rajya Sabha has got powers of the consideration. Rajya Sabha can consider the bill one, and after consideration, he sent it back to the Lok Sabha, or in the lower house, that is in the state house, that is Vidhan Sabha or state legislative assembly. If some recommendations have been made in such money bill, that can be reconsidered by the Lok Sabha or the Rajya Vidhan Sabha. And I will cite one example in the state legislative assembly at one Mr. B.T. Deshmukh was made the recommendation in money bill, that is an appropriation bill. That bill was not sent it back to the legislative assembly, and House was prorogued. At that time, that bill was not taken into consideration by the Rajya Vidhan Sabha, that is state legislative assembly. The bill cannot say that it presumed to be passed. So the legislative assembly was recalled and for one day, and that bill was sent to for consideration of that recommend. Those recommendations were made in that bill, and those recommendations were taken under consideration by the Rajya Vidhan Sabha, and then it's sent back to the council. As you see, once recommendations are made, that is again has to be considered by the Rajya Vidhan Sabha or Lok Sabha, and it again after consideration of that recommendation, it has to be sent back that the House of the People has considered it properly, and then only that bill is presumed to be passed by the concerned House. Unless the any expenditure or receipt cannot be valid, and no one can be spend money without the permission of the House, because a single money, if anyone has to spend, the governor machinery has to pay, or the salary of the government employees, or any fund where it has to be utilized, it should be get sanctioned by the particular House, that is Lok Sabha or Rajya Sabha. Unless the sanction is got, we cannot spend a single money without that permission. So this was the very unique example happened in the Maharashtra State Legislature, which was evidence on the face of record. So the money bill is very important. That is related with the receipt and the grants made in it. So another we can see the ordinary bill. Ordinary bill is can be introduced any of the House, either House of the People or the state, the Council of State, that is Rajya Sabha. It can be introduced, and there are 3 stages to. One is to introduce, another to take consideration, and third to pass that bill. The bill means a legislation on a particular subject which has mentioned in 7th list, Schedule 7, Schedule 7 in list, in central list, state list, and concurrent list. In central list, only center can make law. In state list, only state can make laws, and the concurrent list is there. Either state or the central government can make law on the central list. You may see thousands of legislation have been made out of this list. So nowadays the IT Act, the several laws relating the social media or the telegraphic laws, these are laws are just nowadays when technology are introduced regarding the cyber cafe. All these laws now the laws are made in the central list only. So as the parliament, that is the center, the parliament can make the laws on the basis of the central list, and the state government made the laws only the subject matter of the state. If anyone is going out of the scope, that law can be challenged by any of the people in the court of law, and that can be set aside by the concerned court. Only there is the state law can challenge in the state high court, and the central law can challenge in the Supreme Court of India. So this is very important aspect in relation to the legislature and legislature of passing the law, how to make the law, that is after getting the bill introduced in the House. If suppose any legislation is relating to the people, is relating to the people and their interest, that is public interest or interest at large of the people. People want to involve in the legislation. So the concerned ministry make the draft. Before making the draft, they send it to the general public. The draft sent it to general public to invite the opinion over it. After getting the opinion or suggestions on the draft prepared by the concerned ministry, again that draft is made comprehensively by that department. After making comprehensive draft, it's sent to the state legislature or the parliament, that is Lok Sabha or Rajya Sabha. Either any house, that bill can be introduced. After passing that bill by both the houses, it's sent to the governor or the president of India for final assent. If assent is given, but that bill is not published in the government official gazette, then that law cannot be implemented. If the president has given assent or the governor has given assent and that bill has been passed, and after passing, after assent, that bill has been published in the government gazette, then and then only, as a such date mentioned in that government gazette, since that date, that law can be implemented by the state government or the central government of India. So this is the procedure simply on the floor of the state legislature or the central government, that is the parliament. So another aspect of the legislative business, that is account of that is the annual financial statement. The president shall, in respect of every financial year, cause to be laid before both the houses of the parliament, and the statement of that estimated receipt and expenditure of the government of India for that year only can be laid on the floor of the house. You see, governor personally or the president personally cannot lay that statement on the floor of the house. The concerned minister of the state, that is the finance minister, can lay the such statement on the floor of the house. That is called the annual financial statement. We can say budget also. That is budget in simple word. So you can when the session is prorogued, at that time, after some days, the budget can present by the finance minister to the house. After budget is present to the house, the discussion over it at least 7 days on the floor of the house on every department's grant. The departments put up grants for the vote of the house. Unless that house is not OTT grants, that budget cannot be passed by the house. So that budget cannot be passed and considered by the house. So for getting entire budget passed, there is guillotine put by the legislature for the vote of on the particular grants. If that guillotine is not put up by the legislature, then unlimited discussion will be happen, and the end of the discussion never will be end. So guillotine is put for the end of the discussion and for passing of the grants by the majority or by the house. If this is the compulsory business before the house, and governor to that effect has to make the date to consider the demands in the particular house, and after getting passing of the the appropriation bill can be passed by the house. That bill is called as money bill, and that is to be certified by the concerned speaker of the house. So as by way of the excess grant or additional grant, the reappropriation bill can be put up. Maybe you see, once a budget is passed, and suppose any of the policy is having some short of fund, and to that effect some excess demand, some additional demands has to be made, or some supplementary demands has to be made. So by making supplementary demands, the governor has to make has to sure it before the house that such demand should be laid on the floor of the house for the consideration of both the houses, for the consideration and passing of both the houses. Unless the governor has not fixed the date for considering the demands cannot be considered. So the role of the governor is very important. Why governor is acting on the aid and advice given by the Council of Ministers. Here is the role of the Council of Ministers is very important, because Council of Ministers are elected by the people, and those are just answerable to the people direct. You see, people those are given the mandate to the concerned government or concerned party to form a government. They has to form the council of minister, and he has to select the leader of party, either the parliament leader. So as the leader of the parliament or the leader of the legislative assembly, he can form the government. He can send the list of the members of his party or the majority of the party to the governor. After getting consent of the governor, he can opt to form the government. After the government is the oath is given to the chief minister, then chief minister can give the oath to the another minister. So after form the person, the party who has got the mandate of the people, they can form the government, and the council of minister is the answerable of every proposal sent to send to the council of minister. They has to consider in it, that is the cabinet, and send it to the final assent to the governor. Governor to his fairly has to assent it and send it back to the government for the further implementation. Now you can see, now last few days, one very means unique example has happened in the Maharashtra government. That is, 12 members are nominated by the governor of Maharashtra. Since before 2 years back, the under the constitutional provision that they should purchase the qualification of the art, they should purchase the qualification of art, industry, and social worker. These all qualifications should purchase by them. If the governor is not satisfied of their qualification, he cannot give assent, or he cannot nominate, and it is there that the particular period is not given. Therefore, this has been held up by the governor, and till today that nomination are not released by the governor. Another example of the rules, Maharashtra Legislative Secretariat, under the guidance or under the supervision of the Committee on Rules of the Legislative Assembly, makes certain rules to change the rule election of the speaker in the Maharashtra State Legislature. You see, the election of the speaker, some earlier rule was changed. That rule was relating to the ballot papers. So by secret ballot paper, the member of the Legislative Assemblies has to choose their speaker. And this provision is normal provision, but in the Legislative Council, the rule is different. The member has to choose their chairman by way of filing the nomination and by way of moving the motion before the House. So the two different provisions are there in the State Legislative Council and to Legislative Assembly. Whereas in Lok Sabha also, the member is elected, the speaker is elected by way of the nomination. So as the chairman is ex officio member of the deputy chairman of the Rajya Sabha. He is the chairman of the Rajya Sabha. The deputy chairman, that is the Uparashtrapati. Uparashtrapati is the ex officio member of the chairman of the Rajya Sabha. There is no question to nominate or to elect him, because it is Padasiddha, that is ex officio member of the Rajya Sabha. But the speaker, that earlier he was chosen by secret ballot papers, but some years back the provision has been changed, and that provision is made that he may be nominated by way of motion. Means a member can propose a motion before the House. If that motion is passed by the majority by the House, then the speaker can be chosen. So such type of motion is available before the Legislative Council as per the existing provisions. So the Maharashtra Legislative Assembly has failed that why that rule should not be unanimously accepted. So there is a same form of rule. There should be same form of rule. So the Legislative Assembly thought it, and the proposal sent by the Deputy Speaker to the Rules Committee on the Legislative Assembly. So that the Rules Committee of Assembly has taken the proposal for consideration and make the consider rule 6 and 7 to elect the Speaker of the House. Because you see, after the resignation given by the Nana Patole last year from the post of Speaker, saying that the post is like vacant, and after the post is like vacant, and for preventing the Ghode Bazar, that is horse trading, in the electing the Speaker, the Assembly thought that some members of the Assembly thought that these rules should be changed, and it should be made on the basis of the Legislative Council. So that matter is challenged before the High Court. High Court has given direction that the rule can be changed, and this is the powers and this is the rights of the Assembly. So we cannot, we hail the rulings of the Rules Committee proper, and send it. The judgment is given in favor of the Rules Committee, and rules are kept. The change of rules are kept intact. So here the matter again sent it to the governor. Governor was not ready to give assent to these rules. So matter is now pending. Now that matter, the concerned person who was approached to the Honorable High Court, he again filed the appeal before the Supreme Court of India. You see, these are the powers of the committee. These are the powers of the governor. Governor can consider it, or government can give assent if not. So when governor can act, that fixed provision is not given in the constitution, but it is generally think that the governor should act according to aid and advice given by the Council of Ministers. So these proposals are also sent by the Chief Minister through the Council of Ministers to the governor, but this proposal is not admitted, not assented by the governor. So there are several many other examples regarding the making the legislation. You may see the matter of public importance like the dance bar bill, like the employment guarantee scheme, the right to education scheme, right to information act. All these bills were introduced before the house, and this legislation was adopted by the central government, and these laws are applicable and implemented by the central and as well as the state government for the benefit and public importance nicely. So this is shortly the legislation, and the legislation process can be elaborate, and it can, this subject is very vast. It cannot be completed in very few minutes or even in 45 minutes. This can take much more time. So whatever I have elaborated it, whatever knowledge I have got, I had given, and on this eve of the Jayanti or the birth anniversary of Dr. Babasaheb Ambedkar, at large scale on the in the part of the various part of the world, also the entire India is celebrating the Dr. Babasaheb Ambedkar Jayanti. These colleges are also celebrating the birth centenary of Dr. Babasaheb Ambedkar, birth anniversary of Dr. Babasaheb Ambedkar. The Maharashtra government also given directions by issuing the circular to the school department and education department and the university department to celebrate the birth anniversary of Dr. Babasaheb Ambedkar. Babasaheb Ambedkar has played very huge role to the development of India. He is the real son of the soil of this country. So I am very much thankful to Professor Sri Krishna More, who has arranged this lecture and have got opportunity to deliver the lecture before you. Thank you very much. I am thankful. I am very much thankful. Jai Hind.
Thank you very much, sir, for guiding us on the basics of legislative process. It was really insightful, and we definitely took a lot of learnings from it. Now I request our Vice Principal, Professor Sri Kishan More, sir, to give presidential address.
Thank you, Chaitrali. And before going into the concluding remark, I wish all the best to all the participants of this Dr. Babasaheb Ambedkar birth anniversary for the making it a grand celebration. Honorable Principal Dr. C.M. Rao sir, who is the president of this function. Honorable Atole sir, who is the chief guest and speaker of this function, and my all colleagues, students. Today we have listened very good lecture in the practical aspect of the legislative process, which is provided under the Constitution of India. And actually, I was thinking to arrange this a training program from last few years, and we had a dialogue with respected Atlas sir before 2 years ago, and now it is the opportunity we got, and we have arranged this online mode. Mr. Atale sir have spoken on different practical aspect of the lawmaking process. Actually, we have learned the process which is provided under the provisions of the Constitution. But what we believe that as a lawyer and law student, you should have the knowledge in practical aspect also. Because whatever there are minutes involved, they are only known to the personnel who involved into this all legislative process. And being a respected guest, Atale sir is the in charge of that particular department. And he has actually knowledge of many minute experiences which he had observed into the house through the his own function while discharging the function into the legislative process, legislative department of the Maharashtra State Legislature. And really, I am thankful to Atale sir for sharing his experience, for giving some practical examples to our students. Though they are the law student and they have learned this process, but these are very minute things they must learn. They must keep in their mind that how, in actual sense, law can be made. So one of the point which he had said, and that is very correct, and everybody should know that it is not only sufficient for the president or the governor to give the assent, but what is more again required is that that should be published into the official gazette of the government. Otherwise, if there is assent given by the president or the governor, and if there is no any gazette published, so that law will not come into an effect. So that was the very important point he had said, and some incidences he had shared. Actually, those are having practical importance, and many issues are pending before the state legislature and the Parliament of India. Sir, have also talked on governor's role. And in the federalism, particularly, a governor plays very significant role. And while taking care of any state, because governor is the constitutional head of the state, so he has very crucial responsibility so far as the welfare of the people are concerned. Constitutionally speaking, as a challenges to the provisions of our constitution, in practice, while maintaining the relationship in between governor and the council of minister, particularly in case of Maharashtra, we can have many kind of the criticisms in the academic manner. But this is not the platform for discussing that all. However, being the student of law, we shall take that all in consideration. So we can see that, we can experience that, we can study that, and we can have the opinion on that also, being the law student. So with this, again, I'm thankful to respected Atole sir, and I will be giving him the a further invitation to come to our college, and if it is possible, we can arrange the training program which was in our mind before 2-3 years back. And please, sir, please spare some time for us in future also. I am also thankful to all the audience and my colleagues who have shown their presence. Again, I wish you all the best on the occasion of this 131st birth anniversary of Dr. Babasaheb Ambedkar. the chief architect of our constitution. Thank you very much. Thank you, Chaitra.
Thank you.
Thank you.
Over to you, sir.
Thank you very much, sir. Concluding today's session, we move forward to vote of thanks. I thank Shri Vilas Athavale sir for taking time out from his schedule and guiding us with a lot of insights and for joining us today. I would like to thank our principal, Dr. C.M. Rao sir, Vice Principal, Professor Shri Kishan More sir, IQAC Coordinator, Dr. Aparna Kotapale ma'am, Coordinator for this event, Professor Abhay Zadav sir and Dr. Anju Singh ma'am, teaching and non-teaching staff of MP Law, technical team for today's event, and last but not the least, all the attendees for patient listening. Now, with the permission of dignitaries, I hereby declare that today's event is successfully completed. Thank you very much, everyone, for joining us. Thank you very much, sir.